one motion that we deferred until sentencing, and that was my motion to declare sections 921.141, 922.10, and 922.105 Florida statutes unconstitutional because electrocution and lethal injections are cruel and unusual punishments. We agreed before that that motion was probably filed too early, and I'm not sure when it should be argued, but the court mentioned having it at sentencing. I don't wish to make any additional arguments other than the one in the written motion, because we don't even know right now if there is a death sentence, how it would be carried out in the future, whether the statutes and rules would still be the same.
Would you, it is the court's intention to deny that motion. Would you prefer that the court do that now or issue a separate order? I can just announce it orally on the record, or?
I think orally on the record is fine.
All right.
I don't see any difference.
In that case, the court will deny it. I think it's two separate motions, correct?
No, it's just one. It incorporates both lethal injection and electrocution.
Okay, the court will deny that motion at this time. Contemporaneously with this proceeding, the court is filing a written order which provides the legal basis upon which the court will impose sentence in this case. The court will not read the entire written order verbatim. However, I will read significant portions here today. In 2004, a grand jury indicted Pinkney W. Carter for 3 counts of first-degree murder with a firearm for the killing of Glen Pafford, Elizabeth Reed, and Courtney Smith. By special verdict, the jury unanimously found the defendant guilty of both premeditated and felony murder for each of the 3 killings. This verdict also showed that the jury determined the murders were committed in the course of a burglary. In that penalty phase, the jury voted 9-3 for death for Glen Pafford's murder, 8-4 for death for Elizabeth Reed's murder, and for life imprisonment for Courtney Smith's murder. The court sentenced the defendant to death for the murders of Glen Pafford and Elizabeth Reed, and to life for the murder of Courtney Smith. The Florida Supreme Court affirmed defendant's convictions and sentences on direct appeal. In 2017, this court granted defendant's post-conviction motion pursuant to Hurst v. Florida, Hurst v. State, and Florida Rule of Criminal Procedure 3.851, and set aside defendant's death sentences for Glen Pafford's murder and for Elizabeth Reed's murder. The Florida Supreme Court subsequently denied the state's emergency all writs petition and remanded the case for a new penalty phase trial for Glen Pafford's murder and for Elizabeth Reed's murder. On August the 15th and 16th and August the 19th through the 22nd, 2024, this court conducted the new penalty phase trial wherein the state and the defense presented evidence. The jury voted 10-2 that defendant be sentenced to death for Glen Pafford's murder. The jury voted 9-3 that defendant be sentenced to death for Elizabeth Reed's murder. This court held a separate Spencer hearing on January the 24th, 2025, and both the state and the defendant had an opportunity to present additional evidence and argue the appropriate sentences that should be imposed by this court. In imposing these sentences, this court has considered the guilt and penalty phase verdicts, all evidence presented during the guilt and penalty phase trials, the Spencer hearing, and the sentencing memoranda submitted by the parties. This court now finds as follows. On direct appeal, the Florida Supreme Court summarized the facts leading to defendants' death sentences, original death sentences. Those facts are cited in this court's written order and adopted therein. For a defendant to be eligible for a death sentence, the state must prove at least one aggravating factor beyond a reasonable doubt. In imposing the death penalty, a court may only consider an aggravating factor that was unanimously found to exist by the jury. The state alleged 3 aggravating factors per the statute for Glen Pafford and for Elizabeth Reed. 1, the defendant was previously or contemporaneously convicted of a capital felony. 2, the first-degree murder was committed while the defendant was engaged in the commission of a burglary or attempted burglary. And 3, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The jury unanimously found 2 aggravating factors exist beyond a reasonable doubt for Pafford and for Reed. The jury rejected 1 proposed aggravating factor by not finding the defendant committed either murder in a cold, calculated, and premeditated manner. The jury's findings are both supported by the evidence and consistent with the law. For aggravating factor 1, prior capital or violent felony. The prior violent felony conviction aggravating factor is considered one of the most weighty in Florida's sentencing calculus. On September 27, 2005, a jury convicted the defendant of 3 counts of capital first-degree murder for killing Pafford, Reed, and Smith. During the 2024 penalty phase trial, the state entered each of the defendant's 2005 verdict forms into evidence. Count 1, Glen Pafford. The defendant was convicted of committing the contemporaneous capital first-degree murders of Reed and Smith. Before shooting Pafford, the defendant shot Smith once in Smith's head. Defendant then aimed and shot Reed twice in her head as she ran toward Smith. Both Smith and Reed died from gunshot wounds to their heads. Count 2, Elizabeth Reed. Defendant was convicted of committing the contemporaneous capital first-degree murders of Glen Pafford and Courtney Smith. Immediately after shooting Reed and Smith, the defendant aimed and shot Pafford 3 times in the head. Both Smith and Pafford died from gunshot wounds to their heads. Like the jury, this court finds the state has proven the existence of this aggravator beyond a reasonable doubt for Glen Pafford and for Elizabeth Reed. The court gives this aggravating factor great weight in determining the appropriate sentence to impose. Aggravating factor 2, murder committed during burglary or attempted burglary. The jury unanimously found beyond a reasonable doubt the first-degree murders of Pafford and Reed were committed while the defendant was engaged in the commission of a burglary or attempted burglary. On September 27, 2005, the jury found the defendant guilty of the first-degree murders of Pafford and Reed with a special verdict determination that the killings occurred during the commission of a burglary or attempted burglary. During the 2024 penalty phase trial, the state entered the defendant's 2005 verdict forms into evidence. The defendant admitted he went uninvited to Reed's home with his finger on the trigger of his concealed, fully loaded, and chambered .22 caliber rifle, determined to get answers from Reed. The defendant knew Reed did not want to talk to him, having been told by Reed's son that she was not home. The defendant took the rifle to Reed's home so she would not refuse to talk to him. The defendant told Reed and Pafford he would not leave until he got his answers. The defendant testified upon seeing the rifle, Reed grabbed the barrel and the rifle discharged, shooting Smith in the head. The defendant testified he then aimed and shot Reed in the head, and then aimed and shot Pafford in the head. The evidence fully supports the jury's finding that the defendant unlawfully entered and or unlawfully remained in Smith's home with the intent to at least commit an assault. Like the jury, this court finds that this aggravator was established beyond a reasonable doubt for Glen Pafford and for Elizabeth Reed. This court gives this aggravating factor great weight in determining the appropriate sentence to impose. The court finds that the 2 aggravating factors unanimously found by the 12-person jury have been proven beyond a reasonable doubt as to each victim. This court assigns great weight to each aggravating factor. It finds the factors sufficient to warrant a sentence of death. As such, the defendant is eligible for a sentence of death, and this court must now consider the defendant's mitigating circumstances. The defendant alleged 31 non-enumerated mitigating circumstances. A mitigating circumstance is any aspect of a defendant's character or record and any of the circumstances of the offense that reasonably may serve as a basis for imposing a sentence less than death. The mitigation evidence presented by the defendant regarding his life and this court's determination of the existence and weight of the mitigation evidence apply equally to, but are considered separately, regarding the deaths of Glen Pafford and Elizabeth Reed. Therefore, this court will address the existence and weight of the mitigation evidence only once. The defendant did not request that the defendant be instructed on any statutorily enumerated mitigating circumstance, nor did he present any evidence or argument before the court during the penalty phase trial to suggest any statutorily enumerated mitigating circumstances. However, in an abundance of caution, this court has reviewed each statutorily enumerated mitigating circumstance and now finds that no evidence has been presented to support any statutorily enumerated mitigating circumstance, and none is found to exist. For the non-enumerated mitigating circumstances. A. Pinkney Carter Sr. was cruel and unfaithful in his relationship with the defendant's mother, Geneva Carter. B. Pinkney Carter Sr. would leave the home and his children for days at a time to stay with other women while he was married to Geneva Carter. C. Pinkney Carter Sr. abandoned his family when the defendant was a child and thereafter provided little support even when Geneva Carter moved the family closer to Tampa to be closer to Pinkney Carter Sr. Several witnesses testified that the defendant's father was a mean-spirited, selfish, and unfaithful man who abandoned his family with little to no financial support. The greater weight of the evidence establishes these mitigating circumstances, and this court assigns them little weight. D. Abandonment by his father was traumatic for defendant. In an unsent letter to P.W. written when he was 13, defendant expressed sadness about having been abandoned and neglected. The greater weight of the evidence establishes this mitigating circumstance, and the court assigns it little weight. E and F. Geneva Carter was a dependent woman who lacked a high school education and was unable to support her children without considerable help from others. She and her children suffered financial problems for much of defendant's childhood, resulting at times in a lack of food, transportation, and electricity. F. Geneva Carter suffered from mental health problems, resulting in a hospitalization at Milledgeville State Hospital during the time when she was a single parent. The defendant's aunts testified about the financial difficulties the defendant's mother faced after P.W. left the family. The defendant's mother struggled to provide for the family, and they described the defendant's mother's mental illness that precipitated her institutionalization. The greater weight of the evidence establishes these mitigating circumstances, and this court assigns them little weight. G, the defendant started working part-time at an early age to help the family's financial situation. The greater weight of the evidence establishes these mitigating circumstances, and the court assigns them little weight. H, from an early age, defendant was very protective of his younger sister. The greater weight of the evidence establishes this mitigating circumstance, and the court assigns it little weight. I, the defendant did not get along with Donald Watley, the man Geneva Carter married when the defendant was in high school, and he was an alcoholic who did not act as a good role model for the defendant. This mitigating circumstance was established by the greater weight of the evidence, and the court assigns it little weight. J and K, in spite of the problems in his childhood, defendant was an above-average academic achiever in high school who was also successful in sports and acting and was well-liked by his fellow students and teachers. K, the defendant was involved in ROTC during part of his high school years. These mitigating circumstances were established by the greater weight of the evidence, and the court assigns them little weight. L, while working as a summer lifeguard, the defendant saved the life of a child. This circumstance was established by the greater weight of the evidence, and the court assigns it slight weight. M, after graduating from high school, the defendant attended a junior college for a short time in the Tampa area and worked at a grocery store. The mitigating circumstance was established by the greater weight of the evidence, and the court assigns it very little weight. And the defendant enlisted in the United States Air Force and served honorably for almost 4 years, receiving good performance evaluations. He achieved the rank of sergeant received a top-secret security clearance. He was later honorably discharged to attend college. This mitigating circumstance is established by the greater weight of the evidence, and the court assigns it some weight. O, P, and Q. After he left the Air Force, the defendant attended Western Oklahoma State College, where he earned a 2.8 grade point average while also working at a grocery store. He then attended Oklahoma State College, where he was successful in academics and was elected president of the HPR Majors Club, and he maintained employment consistently from the time he left college until the day he was arrested, and he's received praise from his employers. These mitigating circumstances were established by the greater weight of the evidence, and the court assigns them slight weight. R, in spite of the racism displayed by his father, the defendant does not display racial prejudice. This mitigating circumstance was established by the greater weight of the evidence, and the court assigns it little weight. S, in spite of the bad treatment and abandonment by his father, when he became an adult, the defendant tried to establish a relationship with his father when his father grew older. This mitigating circumstance was established by the greater weight of the evidence, and the court assigns it little weight. T and U. In the months before the murders, the defendant invested time, money, and energy to renew his relationship with Elizabeth Reed. He was devastated when Elizabeth Reed did not feel the same way he did. At the time of the murders, defendant was under the influence of alcohol and Elizabeth Reed's antidepressant medicine. These mitigating circumstances were established by the greater weight of the evidence, and the court assigns them minimal weight. V, there is no evidence that defendant intended for his victims to suffer. This court finds this mitigating circumstance was not established, and therefore assigns it no weight. W and X, while spending time in the Duval County Jail awaiting trial, the defendant comforted and encouraged 3 younger inmates, and the defendant behaved appropriately in the courtroom in 2005 and at this proceeding in 2024. These mitigating circumstances were established by the greater weight of the evidence, and the court assigns them very slight weight. Y and Z, the defendant has maintained good relations with his 2 brothers and his sister and their spouses both before and after his arrest. He remains an important part of their lives, and he has established a good relationship with his nephew, Jacob Slotin, and his wife. These mitigating circumstances were established by the greater weight of the evidence, and the court assigns them little weight. Double A, the defendant has formed friendships in prison and has encouraged other inmates. This mitigating circumstance was established by the greater weight of the evidence, and the court assigns it slight weight. BB, the defendant has behaved well and has not received a single disciplinary report. Since he was sentenced in 2005, he has not engaged in any violence or threatening acts. This mitigating circumstance was established by the greater weight of the evidence, and the court assigns it slight weight. CC, if he serves a sentence of life without parole, the defendant will die in prison. This mitigating circumstance was established, and the court assigns it minimal weight. The defendant, DD, the defendant is 70 years old. This mitigating circumstance was established, and the court assigns it minimal weight. EE, while he was in the Duval County Jail, the defendant donated his hair to a charitable organization. This mitigating circumstance was established, and the court assigns it minimal weight. The court has thoroughly reviewed, carefully considered, and weighed the aggravating factors and mitigating circumstances found to exist in this case. Understanding this process is not a quantitative comparison, but one which requires qualitative analysis. The court has assigned an appropriate weight to each aggravating circumstance and each mitigating circumstance. The defendant wanted answers about his relationship with Elizabeth Reed, and he would not take no for an answer. To ensure Reed would not say no, the defendant armed himself with a fully loaded rifle, concealed it, and carried it into Reed's home in the dark, early morning. The defendant said he accidentally shot Courtney Smith, but he did not try to help Smith as Reed did. Instead, the defendant aimed at Reed's head and shot her twice, and then he aimed at Pafford's head and shot him 3 times. Within moments, The defendant killed 3 people inside a home where they should have felt safe, all because he was upset about his relationship and wanted answers. Before the murders, the defendant overcame a difficult childhood, became a productive member of society, and honorably served his country in the military. The defendant developed and maintained supportive familial relationships throughout his life. These circumstances, however, do not tip the scale in favor of a life sentence for either murder, because the aggravating factors found by the jury deserve and are given great weight. Indeed, the jury was fully justified in its 10-2 vote that the death penalty be imposed upon the defendant for killing Glen Pafford, and in its 9-3 vote that the death penalty be imposed upon the defendant for killing Elizabeth Reed. This court further finds that any of the considered aggravating circumstances found in this case, standing alone, would be sufficient to outweigh the mitigation in total presented regarding the murders of Glen Pafford and Elizabeth Reed. This court finds the aggravating factors far outweigh the mitigating circumstances. Pinkney W. Carter, you have not only forfeited your right to live among us, but under the laws of the state of Florida, you have forfeited your right to live at all. It is therefore ordered, as to count 1, that you, Pinkney W. Carter, are hereby sentenced to death for the murder of Glen Pafford. It is further ordered that you be transported to the Department of Corrections to be securely held on Florida's death row until this sentence can be carried out as provided by law. As to count 2, that you, Pinkney W. Carter, are hereby sentenced to death for the murder of Elizabeth Reed. It is further ordered that you be transported to the Department of Corrections to be securely held on Florida's death row until this sentence can be carried out as provided by law. These sentences will run consecutively to each other and to the sentence previously imposed for the murder of Courtney Smith. You are hereby notified that these sentences are subject to automatic review by the Supreme Court of Florida. Counsel will be appointed to represent you for that purpose by separate order. Further, under Section 922.1051 Florida statutes, a death sentence shall be executed by lethal injection unless the person sentenced to death affirmatively elects to be executed by electrocution. You have 30 days from the date of issuance of a mandate pursuant to a decision of the Supreme Court of Florida affirming the sentence of death to elect death by electrocution by the procedures required by that law. Pinkney W. Carter, may God have mercy on your soul upon execution of this sentence. That will conclude the proceedings. Court is in recess. Madam Clerk, you may have this order. Yeah, that's fine. So where? Here? Okay, thank you. Put it into order.
So you guys did the resentencing, right?
Yeah.
Was it his girlfriend or ex-wife? Ex-wife that you did? Yes.